That's either yes or no. We're not doing notes. We're not doing all of this. And I don't understand. I'm getting some attitude from you, and I don't understand that.
Welcome to Courtroom 101, where lesson number 1 is, don't bring an attitude to a judge who has better analogies than you have excuses. Her Honor just hit him with the ultimate reality check. Unless you're winning 6 rings and flying from the free throw line, keep the attitude at the door. We are starting with a literal slam dunk of a lecture. But wait until you see the charges this attitude is trying to mask.
If you want to wear a Michael Jordan jersey, Michael Jordan could afford to have attitude because he was exhibiting greatness. You are not. So there's to be no attitude towards me in this court. Do you understand? And you will get a job. Do you understand? Am I speaking a foreign language to you?
I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March I was in jail for beating him up. I'm
sitting at Xbox, playing Xbox all day, smoking dope all day, doing nothing, are over.
Is there anything else you think your son needs to be successful? All right.
Yes, Your Honor.
Court will find that the state is in compliance with discovery. The attorney listed on the appointment is Charles Bach.
Yes, Your Honor. I'm an associate with Mr. Bunk. Mr. Jones is aware of that. Mr. Bunk is here present today, has conferred with Mr. Jones. But
all right. Do you have any objection to her standing in? All right. Thank you.
We're all one happy family.
Okay. All right. And everyone else, please make sure you whisper. We are on the record. Mr. Jones, I'm going to show you what's entitled Application for Deferred Adjudication, Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes.
You're going to need to speak up so the court reporter can hear. Back on the record. Did you understand in count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams? Oh, off the record for a moment. Am I wrong? Okay. So that you understand that the state is not waiving the enhancement paragraph. Do you understand that? In defense, is that correct?
yes, Your Honor.
All right. So what's being waived is count 1 only, correct?
That is correct.
Yes,
All right. Any objection to the waiver of count 1?
no objection.
All right. So what you're charged with in count 2 is
Let's talk numbers, and they are terrifying. Because of an enhancement paragraph, which basically means the state is bringing up his past to haunt his present. This defendant is looking at a jump from a 20-year max to potentially life in prison. This is the moment the main character energy usually leaves the room and reality sets in. Would you take a plea deal if the alternative was never seeing the outside world again?
possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment for a second-degree felony is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the state is able to prove the enhancement paragraph allegation, then your range of punishment will be anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
All right. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement paragraph true based upon your plea of true and based upon States Exhibits 1 and attachments.
Thank
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you employed? That's either yes or no.
No.
All right. How long have you been unemployed?
Actual 9 to 5. I'm not even sure. So I do side jobs, moving company.
All right. If you are on probation in this court, I require a job, and I require a job where someone gives you a W-2. You understand?
Well, I want to sue moving company.
You need to provide proof of that. Do you have any children?
Yes.
How many?
2.
What are their ages?
4 and 1 boy.
Who do you live with?
I don't know. Like,
If you're drug tested today, what are the results going to be? For everything, and that includes marijuana, alcohol, all of that. Have you ever used anything other than marijuana? That's either yes or no. We're not doing notes. We're not doing all of this, and I don't understand. I'm getting some attitude from you, and I don't understand that.
And we have a malfunction. The judge is literally speaking a foreign language called accountability, and he's not fluent. She just hit the pause button on his freedom because he couldn't keep his mouth shut. In the legal world, this is called digging your own grave. Pro tip: when a judge tells you to be quiet, you don't say shut up. Let's see if his lawyer can perform a miracle in the hallway.
If you want to wear a Michael Jordan jersey, Michael Jordan could afford to have attitude because he was exhibiting greatness. You are not. So there's to be no attitude towards me in this court. Do you understand? And you will get a job. Do you understand? Am I speaking a foreign language to you? All right, then you need to answer my question. Do you understand that you will get a job?
sure, I will get a job.
All right. So this is what we're going to do. You're going to step back. You'll wait. I'll take up sentencing later. And counsel, if you want to speak to your client about his attitude.
Yes, ma'am.
Thank you. All right, we're back on the record in 2023 CR 5280, State of Texas versus Kevin Jones for defense
Charles Bach.
and state.
Jason Gary.
All right. This is what the court is going to do. The court is going to sentence you to 9 years in prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. There's to be regular UAs, and he needs to be tested for levels. There's a $2,500 fine. That'll be probated. What are the court costs in this case, please? Take in consideration 2023 CR 4278. There's to be restitution to SAPD for drug testing. I'm going to want field visits 1 time per month until further notice. 220 hours of community service restitution. I'm going to ask for parenting classes. Once he completes that, the community service hours will be deemed satisfied. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. What's the cost? All right, the court costs in this case are $325. Will you be able to pay that in installments? Probation, is there anything else he needs? Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right.
Did you,
Yes.
sorry, did you say 9 years probated for 8?
Yes. All right. If he completes everything successfully, then he can always come back.
Yes, sir.
All right. Thank you.
Thank you. May we be excused?
Yes. Who's here on Jamara Simmons?
We're conferring in the back, Judge.
Okay. Did you have a chance to speak with probation?
I did.
All right. Court is calling 2023 CR 5280, State of Texas versus Kevon Alfred James Jones. Could I have parties announced for the record for the state?
Jason Gearhead, your David A. Garcia, attorney for Kevin Jones.
And are you Mr. Jones?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Kevin Alfred James Jones who was placed on community supervision in 2023, CR 5280, for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on January 22nd, 2024 for a term of 8 years? Is that you?
Yes,
All right, state.
Yes, Your Honor, violated condition number 1, on or about the 22nd day, May 2024, in Bear County, Texas, to defendant Kevin Alfred James Jones, committed the offense of evading arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
Your Honor, we'll waive the remaining violated conditions.
No
Any-
objections.
Did you understand by pleading true to violation of condition number 1, court could find it true, grant the motion, sentence you to 9 years in the prison?
yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There's Your Honor,
Yes.
and it's to deny the motion to revoke, continue in willingness probation. The state is taking into consideration clause number 766366, and also to have the individual attend state ISF.
That is the agreement, Your Honor.
All right. So why is he continuing to violate? Why is he violating probation?
Well, Judge, if you look at the 3 conditions, 2 of which have now been waived, the evading, I conferred with the state. It was something I've actually filed a motion for continuance because when you look at the police report, it was an execution of a search warrant at a location not my client's. And he was outside of the house. When the police arrived, everyone ran. My client states that he heard bangs. He was fearing for his life. So he ran and hid, and they found him hiding behind a shed in the area. The report from the probation department shows he's been clean. So that was a stupid mistake, Judge. The state and I looked at it. The motion was to get the video, but we worked out this deal. He's been sitting in jail for 2 months. His mother's present, who supports him and loves him. Other than that, the other violation was something about proof of change of address. And I think when he was arrested, he gave his father's address or something, which is different. And then I think the last one was not completing community service or something like that. So he's been working on doing well. We're hoping that the three months in ISF will make sure that he understands he cannot afford any mistakes. And we're hoping that you grant him this opportunity to prove himself and keep him on probation.
All right. And state with regards to this evading, I haven't seen the police report.
Would you like the police? Pretty much the rendition is that it was a drug house that he was standing outside of and with another gentleman. When the officers arrived, DPS, they did run off and did not stop when asked to stop. And that's the evader.
All right. Thank you. You may continue to confer.
Thank you.
Why is it takes people to get arrested to decide they're going to change their life and they want to do things differently? He should not have even been outside a known drug house. And I don't want to hear, I didn't know it was a known drug house, because if you live in a neighborhood, no matter where you stay, you know what house is the house that you shouldn't be at.
I think the gentleman he was speaking to was his uncle, which doesn't excuse where he was, Judge, but that's the situation we have.
And doesn't excuse giving fake addresses, doesn't excuse any of this. How old are you?
25.
You want to raise your right hand for me? You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Keegan Jones.
Do you know what your conditions of probation are?
Yes, ma'am.
Do you know part of your conditions of probation, you can't hang around people who've been in prison, who are out of prison, who are on probation? Do you realize that?
Yes, ma'am.
So is your uncle out of prison, been on probation, any of those things?
10 years ago. Yes, ma'am.
You can't hang around him.
Yes, ma'am.
You can't hang around any family member who's been in and out, who's been to prison, out of prison, on probation. It's not allowed while you're on probation. Do you want to go to prison? Then why are you behaving like you want to go to prison? Why?
This right here? This is the emotional gut punch. The judge is moving past the law and straight into life coaching. Seeing a 25-year-old man hide behind his mother's tears is a tough watch. The transition from tough guy on the streets to child in the courtroom is a common theme in these breakdowns, but this judge isn't letting him off the hook. Do you think she's being too personal, or is this the wake-up call he needs?
Why? You're 25. When are you going to grow up? And stop asking your mom to come down and cry and do this for you. Your mom should be enjoying the best days of her life, not dealing with someone who's 25 years old. You're a grown man and you're behaving like a child. When's the last time you had employment?
Before this happened.
Doing what?
Working at a moving company.
And how far did you go in school?
I graduated.
And what are you planning on doing with the rest of your life, other than hanging out with people you shouldn't be hanging around?
Need to stay out of trouble.
Well, everybody, I'm staying out of trouble. Are you staying out of trouble?
I try, Judge. I don't know.
Everybody's staying out of trouble, unless it's good trouble.
Yes,
You're staying in bad trouble. And then you come to the court and you want to beg me to give you another chance. And you bring your mom down here when she has to pay for parking. I don't know if she drove or if she took the bus, but she could have been doing something else with her day.
yes,
Instead, she's dealing with a grown man who don't want to behave well. Probation, is this what you all are asking for?
Yes.
All right, I'll deny the motion. Alternate amend conditions to include the MRT, ISF, and upon release, I want him on GPS. And it's going to be partial, and it's for employment only. So what that means is you're going to be on GPS. The only thing you're allowed to do on GPS is go to work and go back home. Who are you going to be living with?
mother.
Does your mom want you living with her?
Yes,
Did you ask her? That's either yes or no.
yes,
If I call her up here, is she going to say you asked her, can I live with you?
yes.
All right. So I see you looking up to see. Is he allowed to stay with you?
He does. But he's gonna abide by the
All right. If you can come forward, please. Move over there. All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. State your name for the record.
Anya Bledsoe?
All right. Is this your son?
Yes, ma'am.
All right. He's saying that he has your permission to live at your home. Is he allowed to live at your home?
Yes, he is.
All right. So he's going to be on GPS. He will only be allowed to go to work. Then he has to come home.
Yes, ma'am.
If he violates those conditions, a motion to revoke is going to be filed.
Yes, ma'am.
Is there anything else you think your son needs to be successful?
If I tell you,
No, tell me.
you need to listen.
Okay.
That's what I say. People are the wrong. Your choices of the people are the wrong thing in your mind. You can't get over. He was raised the correct way. So what he has done, it doesn't make any sense. Following somebody is no good. Be a leader.
Mhm.
That's what I try to teach him. He's a good kid. He really and truly is. It's just like I say, following the wrong, even family.
Mhm.
I have to cut mine out too.
Mhm.
So he will work. He helps me out with everything. He's a good kid, very mannerable and everything. And not to bring up when he was with you first time, like I told him, you went up there and you let that lady tell you when you shouldn't have even acted like she wasn't talking to you. And I told him, you are to apologize to her. That's the proper thing. That is the proper thing because he wasn't raised like that. I love him to death, but I will and he has left home before. I told him, you think you're gonna run around here and do what you want to do? Get your things and go. I can't deal. I'm not gonna deal with that.
Okay.
So, I spoke with him this time. Yes, he did. My mama do the right thing. Okay, because I will call the police. I will turn him in. I don't have a problem with that because I don't need the headache.
All right, so let me just tell you, I'm gonna make sure you give your address to probation because when he's released from custody, that's where he's gonna be staying.
Okay.
And she will give you the phone number of who his probation officer is gonna be.
Yes, ma'am. And I do believe as far as that address thing on his ID is 5.
The verdict is in probation, but it's the leash version. He's going to ISF, an intermediate sanction facility, and then straight onto GPS monitoring. He's starting from ground zero, and mom is the new warden. It's a second chance, but one wrong turn to a known drug house, and that 9-year prison sentence is waiting to be activated. Do you think he'll actually stay home, or is the GPS just a countdown to jail?
22.
Oh, no. Here's the thing. I'm gonna continue him. We're starting from ground zero right now.
Okay.
So he's gonna know where he needs to stay, and that's where we'll be, okay? All right, thank you.
Thank you. And Judge, regarding the GPS, can
All
we
right.
waive the fees?
Oh, just 1 second. Come back up, Mr. Jones. All right. Oh, don't be bowing your head like you have some kind of shame. Your mother is saving your life. You understand?
Yes.
All right. The court is going to deny the motion, alternate amend conditions to include MRT, ISF upon release, and he's to remain in custody until transferred to ISF cognitive. There's going to be GPS partial for employment only, waive GPS fees, and it's going to be proof of employment within 30 days of release. And you are to reside with your mother until further notice.
That's state ISF, right, Judge?
Yes.
Thank you.
Probation, is there anything else he needs? All right, we can go off the record. Here's the thing. You may think you're an adult, but guess what? You're going to be living in your mom's home. So if she has her rules, if she wants the television off at 10, television goes off at 10. If you want to make your own rules, you need to get your own place. And I'm telling you right now, you are not allowed to leave your mother's house or go live somewhere else without the court's permission. Do you understand?
Yes.
Is there anything you do not understand?
No.
Anything else you need from the court to be successful? All right, thank you.
Thank you, Judge.
You're welcome.
Good luck.
All right.
An off docket matter.
Okay.
Mr. Jones has come to the court with some concerns. He's on GPS monitor and he would like to see about getting his monitor times adjusted.
All right. So what times are you requesting?
Well, for right now, I have a newborn child.
Okay. Congratulations.
Yes, ma'am.
Let's make sure we are giving them the best example that we can. All right.
So I was supposed to be at the hospital, and I didn't think I was going to be here this long, but at 2:30, the baby is ready to be discharged.
Okay.
And I have to be there. They don't want me to come in and out from the baby feeding this day, that day. They're going to do it all in several hours.
All right. Any objections to him with the baby at the hospital?
No, Judge, I think there's just other stuff that might be needs to be addressed, and I'll let him explain it.
Okay. So there's no objections to you being at the hospital. Are they still waiting to release the baby? Or have they already left?
No, I need that to do the baby feeding and the CPR class.
Oh, you got to do the CPR classes.
Yes, ma'am.
You know, back in the day, they didn't give you CPR classes. They just said, good luck to you and your baby. Yeah. All right.
I'm a full-time student at a South Texas Vocational Technical Institute.
Okay.
I go to school from 8 a.m. to 1 p.m.
8 a.m. to 1 p.m. That's school.
I'm currently looking for a job.
All right. So 8 a.m. to 1 p.m. school. What days? Monday through Friday. Okay. And then you have the baby hospital. So there's going to be no issues with you at the hospital. Okay. And there's no issues with school. I think everybody wants you to better yourself. All right, so what's the other issue?
So baby, besides setting up appointments for the baby, looking for a job. There's nothing else really.
All right. So, State, let me ask you, is this something maybe tracking with curfew?
Well, Judge, I think, I don't know if it's been said, but my understanding is that the mother of the child was not present,
Mm-hmm.
and that's a concern, because I don't know who's taking care of the child when she's not around and he's not around.
Okay.
So that's just a concern of the state. I think that since it's really public.
All right. Who's taking care of the baby when you're not around? I'm sorry? Oh, isn't it always grandmothers being parents? All right. So he's saying his mom. Any other concerns?
Not necessarily, Judge. I just to let the court know, I did email the school for the state connected leave accommodation wellbeing classes and confirmed that he was attending from Monday through Friday, 8 a.m. to 1 p.m.
Okay.
That's what the coordinator said. And the only concerns are just to make sure that the newborn child was taken care of. That's the other concern of the state.
All right. Let me ask you this with regards to the newborn. So when you're not around and the mother is not around, you say that your mom is the person who takes care of the child? All right.
So it can,
Wait a minute. You're just about to say something important and the machine is printing. Okay. Yes.
daycare services if it's needed.
All right. Please check into daycare services. Just don't take your baby to anybody's daycare. You know, people need to start investigating daycares when you're taking your child there. I always would tell clients that I would have, would you just go to a strange house, not knowing anybody, and you just are in there, or would you want to investigate what's going on? So make sure that you investigate the daycare, because your baby is not at the age, I believe, where they can talk and tell you what's going on, right? So investigate. Just don't drop your child off someplace, okay?
Yes.
All righty. So is there an issue with tracking, or do y'all want to, what I can do is I can try out this schedule allowing him to go to school full time, be with his child and see how that goes, and then maybe move towards tracking only.
Judge, yeah, I mean, the state's been okay with it. It seems like he at least is trying to excel and going to school and being a responsible father. His concern was that the mother wasn't, I guess, present or not able to be present because of possibly incarcerations. And so that was just concern of the state, and it was brought to my attention. Probation.
All right, so let me ask you this. Have you had a chance to talk to his mom?
She said she apologized. She's looking for parking. She didn't tell me.
Oh, she's driving around?
She's trying to find parking.
Oh, let me ask you, can she zoom in? Does she know how to zoom? While I'm driving. Yeah.
Judge, and I did tell the state that in regards to his concerns, there are field visits that are already a part of his condition terms to where our officers will be doing home visits.
Okay, and then what I can say, and as a part of the conditions that I added, was that he's to reside with his mom. So you're residing with your mom?
Yes.
So, all right then. Do you want to do tracking only, and then we can do an update?
That'd be fine.
All right, so what I'm going to do is I'm going to do tracking only. What that means is, really, don't go wild, right? Just do your school, taking care of your child, looking for employment. Don't get sidetracked, because it's easy to get off that path, okay?
Even before I got it put on Friday, I've been at home and just going to school. I ain't been trying to get enough trouble.
All right. Well, I'm so proud that you're actually bettering yourself. Welding is a good profession. Don't burn yourself too much. Well, you know what they say? They say you're not a welder until you're burned. And then I knew an attorney who decided he was going to be a carpenter. He's a carpenter, but he lost a digit. And he said, people say you're not a carpenter until you've lost a digit. As people say, you're not an attorney till you've had a grievance filed against you. There's so many professions like that. All right. So what I'm going to do is I'm going to do tracking only. And does he have community service hours? All right. So, Bashan.
Yes, Judge.
He has the community service hours, but I did put down he completes parenting classes and his community service hours will be deemed satisfied. So do the CPR classes, do parenting classes, and then you won't have to do the community service hours. All right, so they'll be tracking only, and then we will recall this for, you all want to recall this in 30 days or 60 days to see how things are going?
Either.
All right, at 2 p.m. I'm saying 2 p.m., but I'll write on the docket sheet 2-ish because sometimes traffic is some kind of way. Well, congratulations. I'm glad you're doing well. Keep it up, okay? All right, thank you. Yes, Norma, can you give him a reset form and put 2-ish on there, please?
Barnes and Barnes versus Mahmood and Miller. Your name, sir?
Devin Miller.
All right. And Miss Mahmood, is she here or no?
Yes, she is here, but I think she's having some difficulties right now.
Your Honor, we haven't received a payment since the last time we were here. It's $26.65 total. $25.65. I'm sorry.
$25.65.
Oh, so I recently just received employment, so been waiting for my check to come between that time.
I have a note that $1,000 was going to be paid. I don't know why.
$1,000?
Okay. Well, how would you intend on getting this paid off?
So I don't get paid until the 28th. And then
Until the what?
the 28th of June.
Okay, but all right, let's take that. And how much would you be willing? How much are you going to be able to pay?
So with me working weekly, I get paid $5.60 on a full
On a full check, you get how much?
$5.60 minus tax.
Because I don't know how we're going to do this if she's not here, because I'm about to. I mean, my inclination is to issue a judgment.
Well, we've been having some difficulties in being uncooperative.
Pardon?
That she was being uncooperative. I would hope that you don't throw it out because I'm really trying.
She was being uncooperative.
I apologize for interrupting. I have an eye out front, but she doesn't want to come to the courtroom because of a contact order between her and her husband.
We don't have one, sir, Your Honor.
Are you her husband?
Yes. May I explain?
Please.
Okay, so recently she's having a spat with me. She's just upset that she wanted me to apologize for a misunderstanding that we had before coming here to court. When she got verbally volatile with me, so she decided to.
Okay. That's fine. Is there a no contact order between the two of you?
No, there's absolutely not. She probably just said that just to make things worse on my end.
Well, they couldn't get much worse.
Yeah, I don't.
I'm not really sure. She can be very vindictive.
Okay, so let's not say that out loud. Can you go down the hall and
Sign on to Zoom?
no here? Yeah, well, ask her if she's going to participate in the hearing. Him over here, sir. Yeah, see you. Ma'am, what's your name?
Miriam Mahmood.
All right. There's a total amount of 2565 owing. Was there a method by which you were intending on getting this paid? Or do you know?
I'm going to be very honest with you.
Talk about a tonal shift. We just moved from criminal court to a civil nightmare. Mario isn't just refusing to pay, she's pouring her heart out about a broken home, a failing system, and a house with no heat. This is the raw, unscripted side of the law where there are no winners. She'd rather sleep in her car than fight for a house that feels like a prison. How do you even begin to judge a case when the person in front of you has clearly lost all hope?
Judge.
Okay.
I have no intention of paying one penny. No intention of paying one penny. I've been with Barnes and Barnes since 2021 in this place. I've been with Barnes and Barnes for about 6 years now. Before that, I was in different apartments with Barnes and Barnes. Before that, I've been in EMU since I was 16. Eastern Police, Ipsy Police, all y'all have just failed me. I've been begging Barnes and Barnes to fix my house for a simple fan, for heat in the winter. I'm having to take money out of my pockets to keep myself fed. I would rather sleep in my car than fight for a house, because along with that, I'm dealing with my mom not cooperating and being in cahoots with him. I'd rather win a settlement than fight for this and give my last tears and blood, sweat, and tears into this. My husband doesn't understand how to speak to me nicely. That's why we're not standing here together. And I'm not gonna stand next to a man who doesn't know how to open the right door instead of the left door and snap at his wife. I'm not going to do that. I walked out because in March, I was in jail for beating him up. I'm not going to stand here and go out of my character and act irate when I don't want to fight for something that's mine. That's not, he claims that it's his more than mine. I brought him into my house. I gave him my car. I gave him the clothes on his back. I'm not going to fight for this anymore. I'm exhausted, tired, and hopeless. Ipsy Police was in my house today at 5 a.m. when I asked for harassment. I filed a PPO. I'm getting no help. I'm hopeless, frustrated, and exhausted, and I'm done.
Okay. I just had to make sure, which is why I wanted you in the courtroom, that I was going to find no tribal issue. I was going to issue a judgment to the plaintiff. And I just wanted to make sure that you understood what the court was doing, which is why I wanted you here. All right. So the court finding no tribal issue under judgment for possession and money. So you requested for possession and money as to both defendants. Total amount, the 25,600, that was inclusive of costs, correct?
Yes.
In the total amount of $2,565. And an order of eviction or writ will issue in 10 days. Right. Thank you.
Sorry, could you say that again? I speak 3 different languages. I'm not American. I'm British. So I didn't understand one word that came out of your mouth. I'm sorry, sir.
The whole thing?
You're throwing legal words at me, sir. I'm mentally, I'm in middle school. I didn't pass, I speak 3 different languages. I'm not educated.
Okay.
So I don't understand when you throw legal terms at me. I need to speak to me like a toddler. I would understand that better. Thank you.
I'm issuing a judgment. I'm signing a judgment, a piece of paper indicating that plaintiff, your landlord, has the right to possession of the premises.
Okay, so
unless $2,565 is paid prior to July 1st or by July 1st. If it's not paid by July 1st, they can then file for what's called a writ of restitution or an order of eviction to have you move. Either at that point you can move by then or you can pay the money by then. If you fail to move, what will end up happening if they file that order of eviction, the court will sign off on it. And then what will happen is the sheriff, another police agency, or the sheriff's department or a court officer will show up and will, if you haven't vacated the premises, will remove you from the premises.
Or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 1st, 2024, officers conducted a traffic stop for a vehicle with no front license plate in Harris County, Texas. The officers made contact with the defendant, the driver of the vehicle, and observed an odor of marijuana. A search was conducted and officers observed a black plastic bag under the front passenger seat containing marijuana and drug paraphernalia, such as a weight scale, a bong pipe, and multiple small bags. The officers also found marijuana grinder in the trunk of the vehicle. Marijuana was identified based on training experience and had a weight of 65.9 grams.
Mr. Foster, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Upon the traffic stop, I found out that it was suspended.
I want to impart something to you that I am making it a bond condition for you now that you're not to drive any vehicle for any reason. I don't care what your reason is. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care if there's a burning building or Mother Teresa needs to go to church. You get into a car and drive, there's going to be HE double hockey sticks to pay. Do you understand? What do you do for a living, Mr. Foster?
Sir?
What do you do for a living?
I do for a living, landscaping.
We're going to reset your case, give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. After that,
can I file for an attorney from the state?
Why?
So I don't have money for a lawyer.
How do you know? How do you know?
Well, it's not my first time, dealing with lawyers, and I just don't have that kind of money right now.
2018, unlawful carrying of a weapon. 2019, criminal mischief. 2018, assault of a family member. 2019, assault of a family member. 2021, criminal trespass. 2022, unlawful carrying of a weapon. 22, felony possession of marijuana. And now you've gotten another possession of marijuana. In all of those cases, how many times have you gotten a court-appointed lawyer? Yeah, right. I want you now to go looking, and I want you to get a full-time job. And I am now making that a condition of your bond as well. The days of you sitting at Xbox, playing Xbox all day, smoking dope all day, doing nothing are over. I am making it a condition of your bond that you get a full. You've got that smirk on you. And I'm going to tell you now, it's not going to go well if you try to play with me. Do you understand?
I don't need to go spend my money when I'm taking care of my family to get a lawyer on a case that, you know what I mean?
No. I want you to go start looking for lawyers.
Okay.
And I want you to start Googling Harris County lawyers. There's a gajillion and one of them. Mr. Foster.
Yeah, they calling my line. They sending papers to the mail. Y'all know.
Okay. Start calling those and finding one you can afford.
Okay.
You pick up a new case. You start driving. I'm telling you now, I'm going to revoke your bond and I'll make it sky high. Do you understand?
I understand.
I'll tell you this though, Mr. Foster, you look like you have a lot of arrogance to you. If you put that arrogance into working really hard, holy moly, you could command the entire world. I know people who started as a freaking dishwasher at Chick-fil-A and they worked their ass off. Now owns two of them making 400 GER a year. That's hundreds of thousands every month that he's raking in because he put his chutzpah into working and his heart into working his ass off. And now, dude, he's killing it. And people thought he was a joke working at Chick-fil-A. And dude's this is the American dream. That's what it's about. Not this, not what you're trying to sell. Don't. Put your heart, soul into it. You can do anything. That's what makes this place so great.
We're here in cause number 19-32623. And we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalvius Williams. And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, is my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussion with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that was true. And do you want to continue to plead true to that count? Okay. And then count 2 alleges that you're behind in your court assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count. And do you want to change your plea of true in that count? You want to change your plea to not true? Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses to which they're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
On the front door, so we need both of them.
Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's been, oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were and all of that this morning. Is that correct as well? Okay. What if any offers? I want to make sure Mr. Williams on the record rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case and force off the table on this case.
Okay.
I apologize, and I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked.
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what you could do today and kind of where we're about to go, right? And so what do you want to do?
To kill first, but not to the injury to a child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record, what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. Starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail. And then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense from January of 2019, an attempt to take an officer's weapon, Also, same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Is that everybody on the same page as that?
Yes, Your Honor.
I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. As I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, that was the victim in that offense?
Was the stepson, Your Honor.
So Ms. Broussard has other children.
Yes.
That are not from Mr. Williams.
At least one, Your Honor, yes.
So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true. And at this time, I am going to find count 4 true. I understand everyone's position. I think with regard to there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that. And obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report. And they were recommending that if probation would be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that, after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
Thank you, Mr. Rojas.
Judge,
Mr. Smith.
His criminal history shows fairly convincingly that he is unable to successfully complete probation. A big probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a habit. The fact that he doesn't respect authority is shown by the jail incident reports. I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, the probation officer, do you have anything to add at this point with regard to your position?
No, ma'am, I concur with Mr.
Okay. Thank you, sir. Mr. Rojas, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No, Judge.
Okay. And Mr. Williams, you're 30 years old? You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, it's ridiculous. You and Ashley both don't need to be around any children. don't need to be having more children. You can't take care of your own children, and you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement that when it was signed. I'm making a modification. Let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment regarding, hold on a second, regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has improperly disciplined, if that's what you want to call it, all of these children. So, court is adjourned. All right.